I am Dr. Kasibhatla, presently working as Additional Legal Advisor in the Ministry of Law and Justice, Department of Legal Affairs. And basically, I am concerned with tendering advice to various government departments, ministries, dealing with all cabinet proposals, examining the international treaties, investment treaties, particularly the bilateral investment treaties, conducting litigation on behalf of the Government of India before various fora, both national and international. This is briefly about my assigned duties as on date, and any other duty as assigned time to time has to be performed by me. With my little knowledge and experience of more than 30 years in the field, I see this is a very revolutionary and welcoming step, the introduction of the proposal of the bill 2024, because if you observe the evolution of the arbitration in India from 1996 to 2024, there is a paradigm shift. The paradigm shift was first introduced in 2019, where a decision was taken to shift ourselves from ad hoc arbitration to institutionalized arbitration. So the 2024 bill focuses more on institutionalization of arbitration, not only to conduct domestic as well as international arbitration in India, but also to make India as one of the biggest hub for both domestic as well as international arbitration, including the treaty arbitration. That is the purpose. So several changes are under consideration, like the appeal or the setting aside the award under 34, 37 of the Arbitration Act, and passing of the interim orders, intervention, restricting the jurisdiction of the courts as far as the interim orders are concerned, because there are a number of cases where the aggrieved party will go to the court and seek an interim direction that may hamper the very process of the arbitration. So that is one of the major initiatives under consideration, and also coming up with the Arbitration Council of India to streamline the whole profession of arbitration in India, as I mentioned, to make it as one of the biggest hub for international arbitration in the world. Artificial intelligence is really playing a pivotal role in legal research and in streamline the case search and the case analysis, because physically if you want to do that, it will really a time consuming, whereas artificial intelligence will provide you in a very short time a very crisp analysis of the cases, and it will do its own due diligence on your behalf and provide the accurate results. So it is very much useful and an important tool in the legal research. I see it as a laudable step, and it's a pride and privilege of every Indian, because it's the second of such opportunity we got, and look ahead for such incidences or such opportunities in due course of time, because there is no dearth of knowledge or experience as far as India is concerned. So I'm sure and more speculative that we'll have more appointments in due course of time. I use Jus Mundi very frequently because I deal with all being an advisor to the Ministry of Finance, especially the Department of Economic Affairs. I deal with various investment treaty related issues like negotiations, conducting of negotiations, participation in the negotiation, handling of investment treaty disputes, because so far I handled almost all the investment treaty related disputes, starting from Enron to the present ongoing cases. Jus Mundi is a very important, useful tool because it is an exclusive domain, to my little knowledge, which offers facilities on investment related issues. All the cases, arbitration, not only the cases, it also provides the book reviews, articles and analysis that is very much useful and relevant as far as the investment treaty cases are concerned. Especially while handling cases relating to civil aviation and cases relating to energy sector. This is very much useful because I have a lot of cases. I found a lot of cases and analysis, especially from Energy Charter Treaty to the NAFTA and the EU CAFTA and TPP. Various cases have been analyzed. So I took a reference of all these cases and used the material for strengthening the India's stand in various international investment treaty arbitration cases. So I definitely support that. Yes, it is a very important asset to instrument for handling the cases from legal perspective. So my favorite feature is a sitemap because it not only enables me to look for the case analysis but also comparative analysis and cross references. The case analysis will definitely provide an in-depth study and an in-depth understanding about the various issues. For example, when I made a search about third party funding, I got a lot of comparative analysis, and not only that, even interpretation of the MFN, say the most favored nation interpretation an in-depth analysis and a wide range of cases, covering of the cases. Apart from that, it also simultaneously suggests the relevant authorized books to make further reference. So the case study will have some cross references also. That is more attractive, and I found it more interesting and relevant.